Thursday, January 17th, 2019, 7:30 p.m. I'm calling the regular meeting of the Zoning Board of Appeals for the City of Clawson to order. Could everybody please rise for the Pledge of Allegiance? I pledge
allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Victoria, could you please call the roll?
Ms. Diane Smith.
Present.
Mr. Cook. Mr. Hildebrandt.
Present.
Mr. Sinaki.
Present.
Ms. Scripture.
Present.
Ms. C. Smith.
Present.
We were sent the minutes by email. Has everybody had a chance to review the minutes from our last meeting, September 20th, 2018?
Yes.
I didn't. Can I just take a peek?
Sure.
Thank you.
Did you get your email? Because
No.
Cindy said she didn't get an email either.
And I forgot to pull it down.
Okay. Did you get an email?
I got an email.
Okay. How about you, Reese?
Actually, no.
Okay. Could you check with
I will.
Susie on that?
Okay.
Okay.
And I did look at the Clawson website this afternoon, and there was no email.
They weren't posted there?
No.
The agenda was, but there wasn't anything in council packets, right? Or the packets. Yeah, I didn't see anything.
Correct, I did not.
Yeah.
I did not get it to my City of Clawson email. I got
Yeah.
it to my original, personal email that I started with, and then they gave me the City of Clawson email.
Yeah, that's how I got mine, is through my personal email.
Okay.
So is the intention to communicate with us through the City
City.
of Clawson email
Yes, the
accounts
City
or the
of
personal
Clawson.
accounts?
We should in the future have all through the City of Clawson email accounts.
Okay.
Could we please get redirection on how to access those accounts?
Yes, I will make that happen,
Thank you.
or Victoria will.
Yep, absolutely.
Much appreciated.
So do we need a motion to accept the minutes?
Yes, Ed is reviewing
Oh,
them right now.
sorry.
He didn't have a chance to look at them.
Just to kill some dead air, just making it known to the public that the city will not be open on Monday in honor of Martin Luther King Day.
Thank you for the update.
I'll kill some dead air too and apologize for my tardiness. I have, as you know, Chairwoman Smith, teenagers that are driving now, and they took my vehicle and didn't return it in the timely manner in which they had promised. So
What's the consequences?
it's still under review. Yeah.
Yeah. I'm sure your daughter's going to be excited you discussed that with the City of Clawson.
Now.
It is frightening when they start driving.
driving, working, telling us they want to buy a car.
Thanks for the time. I went over the notes from our previous motion from the variance request on the 0-foot setback. And they all appear to be, according to my recollection of what we intended to do. So
Thank you, Ed. Do I have a
if
motion?
you need a motion, I make a motion that we approve the minutes as published.
Okay, we have a
Second.
motion
Support.
and a support. Victoria, can you please call the roll?
Mr. Hildebrand,
I support.
Mr. Sinaki,
Yes.
Ms. Scripture,
Yes.
Ms. C. Smith,
Yes.
Ms. D. Smith.
Yes. Motion carried. So the next item on the agenda is, this is our first meeting of the year, is an election of officers. So our board has a chairperson and a vice chair. Do we have any nominations for chair?
I nominate you.
Let
Support.
the record show she was pointing to me. So do we have any other nominations for chair?
Oh. Do you accept the nomination?
Yeah, you have to,
Sure. And then do we have any other nominations from the left side of the table?
No, I'd lend my support to your continuation as chair if you so choose. It appears that the meetings have run very pleasantly and efficiently, so.
Thank you, Ed. Yeah, I'll accept the nomination. Victoria, can you please call the roll?
Mr. Sinaki,
Yes.
Ms. Scripture,
yes.
Ms. C. Smith,
Yes.
Ms. D. Smith,
Yes.
Mr. Hildebrand.
Yes.
Thank you. Our vice chair position is also available. Do I have any nominations for the vice chair?
I nominate C. Smith.
Thank
Mr.
you.
Sinaki, would you like to have an opportunity to vice chair?
No, I respectfully decline based upon the fact that I'd like to be able to be more vocal in the development of either the acceptance or the denial of any variances. And I think I can do a better job from here. So thank you for the nomination.
Thank you, Ed.
But I think it would be better for someone else.
Okay.
Okay.
Cindy, do you accept the nomination?
I'll accept the nomination for vice chair.
Okay. Do I have any other nominations for vice chair? Okay. Victoria, can you please call the roll?
Do we have, who's second the
Oh, I
motion?
thought Ed said.
Oh, Ed,
I'd say
I'm
I
sorry.
support.
Okay.
Yes. If I didn't, I do, or whatever.
Ms. Scripture,
Yes.
Ms. C. Smith,
Yes.
Ms. D. Smith,
Yes.
Mr. Hildebrand,
Yes.
Mr. Sinaki.
Yes.
Thank you, Cindy, for your service.
And you as well. Thank you.
I will go ahead, and the next item on the agenda of the introduction of Giffords and Webster as our planning consultants. I'll go ahead and turn this over to Jim Albus.
I'm sorry, nobody from Giffords Webster has shown up. They have taken over the planning services for the city of Clawson from McKenna and Associates. You are familiar with their company because they did the DDA master plan and have worked with the city before. Some of their employees, I think we've known for over 20 years, so They're quite familiar with the area, we're quite familiar with them, and they'll be working out well with us. So, unfortunately, I didn't get that to introduce anybody tonight, though. So,
Now, is it an extended multi-year contract,
it's a 2-year contract.
2-year?
Will they continue to actively support our Clawson DDA?
Yes. One of their starting priorities would be putting the zoning ordinances together for the DDA to match the new master plan of the DDA. So we're going to be doing a lot of ordinance revisions here in the near future.
Okay. Any questions for the city on that?
None?
Okay. And the next item on the agenda is public discussions. Public discussion items not on the agenda. Don't let the record note there's nobody in the public to comment. So the next item on the agenda is other business. The Pep Boys settlement update. I believe our city attorney is here to address this issue.
You have in your file a Pep Boy update that was distributed, laying out the background, how that came about. And short and simple, the applicant pursued under the wrong statute. I do know that I had discussions with Greg and Jim regarding a possible resolution of the issue with them. We couldn't come to any conclusion on that, so the hearing proceeded and they permitted their proof. From the date of the filing of the minutes of that meeting, the applicant would have 21 days to file an action in the circuit court. And I was contacted before those minutes were published by Dickinson Wright, the law firm that represents the County of Oakland in the flood litigation, and with Peter Webster, and I've had dealings with him in the past. Prior to that time, I had looked at the ordinance elsewhere regarding non-conforming uses, and the circumstances seemed to indicate that this would have been a situation, had they gone under that ordinance, they would have gotten it, because there was no interruption in the business. It was the same kind of business, and our policy had been to allow those signs to continue. The policy also was on non-conforming large signs. The goal was to have them removed either by negotiation, number one, or if there was an absence of a protracted period in which the business wasn't being used, they'd lose it then, and other techniques and we've been successful in that. Kimco is one where through negotiations they reduced their pole sign to this permitted sign. I talked with Peter about it. I didn't say anything other than that I was not going to be involved in that litigation, and the city would probably have someone from Johnson Rosati involved in it. But I did indicate to the council that there was vulnerability. The case was before a judge that has an inclination to maybe go against cities. The assertions they were making generally were under state law on non-conforming. They didn't reference our own statute that allowed for that sign to continue, but the state law did to some extent. So the discussion centered around the vulnerability of the city in losing that. And if they lost the lawsuit, they'd probably have to pay legal fees. So the decision was made by council to work with Dickinson Wright through Johnson Rosati to get a settlement. I think you have in the file the settlement that came out. I was involved in those discussions at all, or that settlement discussion, but that was the end of it. And there was no cost that had to be paid. That's how that came about.
Why didn't they have to come back under the right ordinance?
Well, that becomes a little tenuous. I mean, here we are in a hearing, and their presentation was very thorough, and the board made a decision. Now, at that point in time, if we find out later that maybe they did the wrong thing, it's hard to say, oh, by the way, you want to do it over again, particularly when they have a new law firm.
No, I'm
And,
not talking about, I'm talking about in front of us.
oh,
What I'm saying is, they came in initially
yeah.
under the wrong, they asked for a variance under
They
the
applied
wrong
for-
section,
The
correct?
wrong section.
My question is, why then weren't they required to come back under the correct section so we could review it properly under the correct section and then issue whatever it should have been?
I can't answer that, because the Webster firm got, the Dickinson Wright firm got involved in it fairly quickly, and we didn't discuss with them about coming back. They decided that they wanted to stay with the court filing and try to resolve it.
I'm just thinking that's a
settlement.
really good strategy. I think I should come, I'm gonna ask for a variance under the wrong section. I'm gonna get declined, who cares, because I don't care, and I'm gonna go now sue and say, oh, yep, that seems like an
That is one
outstanding
alternative.
strategy.
That's one alternative.
Well,
And that does
that's-
happen. You know, they have the right. We could have offered it to them, I suppose, and they could have refused. But at that moment, with my discussions with Dickinson Wright, they were gonna sue.
Now, I apologize because I did not get the package. So you're referencing the settlement and it was for the sign and its color?
No, it was just, remember, we told them they couldn't have the sign because.
Yeah, you
it was
couldn't
a
have
change
the
of
sign.
business. You're talking about the tall Pep
Yeah,
Boy
yeah.
sign.
Right.
Yeah.
Yeah. We didn't, it wasn't about the color.
No.
It was a non-conforming sign because it was whatever the height it was.
was a pole
We-
sign.
You know, yeah, it's a pole
Yeah.
sign. So we don't allow pole signs, but we have, what the city has done is said, instead of going around and saying, everybody take your pole sign down and replace them, they're saying, if there's a change in, you know, and it's written out or whatever, but if there's a change, then we would require you to go ahead and change your sign. So they did that with Clawson Corners, we've done that with several of them, and they came in front of us and asked for a variance to keep the sign, the pole sign, and and there's that, if you go back and watch it, Greg said several times to them, are you sure you want to do this under this particular, you know?
Right, I
whatever?"
remember
You
there. I was
remember
sitting
that.
there,
And he-
yeah.
I mean, he told, and they proceeded, went ahead with it after being advised several times, are you sure you want to do this? And they went ahead with it, and we, of course, followed, you know, our rules that we had to follow, the ordinance, we declined it.
Right.
And then they proceeded to sue.
Well, for
but
the
they-
future, is there anything differently that we could have done as a zoning board to protect the city from this type of litigation in the future?
This
I mean,
is a
there's always
strange
going to be a
situation.
one-off situation.
Becomes a situation where if that happens and we think someone's doing the wrong section, is it our obligation to then tell them when they have a lawyer? Maybe you want to look at a different section. I mean, that's all we can do.
Right.
And it's their call. And those lawyers were involved in this action months before, getting all the documentation they needed to frame their argument, and they presented a darn good argument
You mean months before here or months before?
months before the hearing. So, but they were all focused on one area. I mean, that happens at times.
So what can we take away from this experience as a learning opportunity?
It's hard to say there's a concrete rule that is followed. And I think one of the things might be that maybe the direction to administration is that if there is a potential of litigation that might arise from the application that's being made, just because of the background, the tenacity, the nature of the applicant and so forth, should there be a confidential document provided regarding an alternative. Now, that gets into a thorny area because you haven't heard the petition yet, and here you're going to get legal advice saying, maybe you ought to give us authority to readdress this with the applicant. That's thorny too. So it's not an easy situation that I can give you an answer that's all black and white and says this is what it is. I think the only thing I can say is that if the circumstance arises again, maybe we advise you. in some manner. And I can't say what manner.
That leads to my question that I was going to ask. I wasn't here, so forgive me. I wasn't
Right.
on the board at that time, but is there any way that this situation can be prevented from happening again by maybe tying up this loophole or in some way creating a bylaw, a rule that if this does happen where it's brought to the board under the incorrect statute, that it automatically can't be, the vote on that can't be counted in some way, or it has to be re-presented under the correct statute before any litigation can happen.
All right, I'm going to answer that in this fashion. I think if those circumstances come up again, with the knowledge that Greg had and Jim and myself, then maybe it is the direction that we put our heads together and say, you may want to look at something else in doing this. Now, it's up to them to determine whether they're going to exercise that. It's not up to us to tell them what to do. Only to point it out and take it that way. That still keeps you out of the process if you're going to hear one or the other, so it keeps you out of the process, and it forces on us a responsibility to become a little more forward in what the downside might be and have the direct conversation with the applicant. I mean, this is the first time I've ever seen a situation like this where the theory advanced for the variance was totally wrong.
Yeah. And I happen to agree with Ms. Scripture. I mean, this is, in theory, and this is definitely a good strategy. I mean, that's all you got to do at this point, is submit under the wrong statute. The board's going to decline it anyways, but then you file a lawsuit, you're going to get what you want anyways. I struggle with, isn't there a way, I feel like there should be a way for the board to be able to protect the city in some form.
It's not necessarily your role to protect as much as it is the role of administration to act on it and carry it forward. Your role is under your ordinances that you have the authority is the case presented for a legitimate variance? And the standards are there. And if the standards aren't presented in general, if the standards aren't presented and don't meet the threshold of the ordinance, then you deny them and you give your reason. And that's the way it should work. So, I mean, it's a very responsible role you play. And we got to make sure that the record is made so your decision is one that is precise, factually based, and definitive.
So then, to what the point being made, is it an issue with the ordinances in the first place?
No, this is the first time we've had this. However, when we go to large lots, it may be there.
Okay. Then my second question is, I can't remember, when did we have the meeting with Pep Boys? That was way back in, like, June or something?
It was in the spring,
Spring?
wasn't it?
I think it was in the spring. And when did they settle? I think it was August? I think it was an August meeting.
Yeah, because there was time, there were a couple of meetings that were missed, so they had to wait for the minutes to get corrected or presented and approved.
And how many times, I know I missed a few because I was out of town, but how many times have we met since August? Because I know I wasn't here at the last one.
Once,
We
September.
only met in September.
So we met in
Yeah.
September.
That was
So how come they didn't get updated on it in September?
Hold on. The settlement agreement was in September.
Was it in September?
Yeah,
That's when it was
after your
signed?
meeting. Yeah.
No, it was dated September 5th. I do have a question about, and then maybe this is a question for city council, but it seems to me that, the city's focus has always been away from pole signs. And then we got into this situation where we had to settle and accept one. Is there discussions in the ordinance to tighten that up a bit, that now it seems to be it's a change of the use, or if they lose a C of O, that it used to trigger, the site plan approval would trigger the review of the sign. But in this case, we just set a precedence that the use of that building didn't change, and so then that sign can stay. So is there,
We formalized that. Informally, that was a practice. But then we formalized it by virtue of that settlement.
Wasn't there something about the land wasn't sold, and therefore that was their loophole?
Yeah, but it was
Yeah.
still, it hadn't consummated, but still it was going to go through.
Right.
Let me say this to you, and it's not a direct answer, because based on the Reed decision that came out 3 years ago on signs, there's a mammoth overhaul that's going to be done of the sign ordinance.
what's the Reed decision?
Reed decision basically concluded that you can almost have no restrictions on signs unless they meet health, safety, and welfare standards. There were 3 separate opinions in that case, all sustaining the majority verdict that the signage was invalid and unconstitutional, or not unconstitutional, or
It's
wasn't
a
constitutional.
U.S. Supreme Court decision on signage.
United States Supreme Court.
Calling it Reed didn't help them.
Yeah, and it just has changed everything. There are a lot of sign ordinances that are multiple pages. And the viewpoint now is looking at, based on the 3 opinions in Reed, what are they really saying? And what can you do to meet the threshold of those 3 different opinions? And so we've been noodling it, and I mentioned it with Rod Arroyo about working with them on making a sign ordinance that is really short and not the number of pages you have right now. But Reed is a significant decision, and each opinion gives you an outline. So all you have to do is use that outline as the purpose of your sign ordinance, have an exhibit about all the signs that are permitted, and then a clause that demonstrates the rationale of public health, safety, and welfare regarding those signs. And then you have a variance provision on all the signs, just like you do now. That's the rough concept. But
I'd like to give a simpler explanation.
he's more pragmatic, so he's going to.
Our ordinance has a sunset provision for all pole signs. That was the end of 2012 or 2014. At that time, we still had approximately 60 pole signs in the city. And it was put together a policy, instead of forcing 60 businesses in the city to immediately take down their pole signs, to activate a policy of anytime a business became vacant and/or changed, went in front for a site plan review, that we would get the pole sign removed at that time. The Supreme Court decision, a simplified version is you can regulate the location and size of signs, but you can't regulate any of the content of the signs. So the wording of the signs.
But we weren't looking at content. We were just looking exactly what you just said, size and location.
Right. There was 3 different decisions by 3 different members of the Supreme Court, and they all
You mean
followed this.
dissenting opinions or decisions?
Yes, consenting
They're all
opinions.
consenting. The majority was, they were 4 on one, and then you had a separate one, and then you had one with 2 others. At that time, Scalia was not along, he had passed away. So you had 8, and they all had the same thread.
So
That's the first time I've seen something on signs like that.
our signs ordinance has multiple sign sizes per district, and I think it's going to be simplified into one size area for commercial districts, maybe one size for industrial, or if we combine industrial, commercial, and one size for residential districts. And then there'll probably be some special wording for elections and placement of signs for those districts, or for those time periods. correct?
Right.
So we currently have an 80-page sign ordinance that's going to be reduced quite a bit.
Very nice.
With the pole signs, I still think it is the intent of the city to remove pole signs whenever possible. But we're going to have to work out the details of when and where and straighten out this issue that occurred with this last agreement. So,
Well, they're all case by case and unique, so just because this one happened doesn't mean the rest will follow suit.
well, that's what you've had a couple of sign variances here where the pole signs remained because of a corner clearance incident where you had to keep it above 8 feet. And then one where it was the sign was going to be obscured by the parking spots directly adjacent to it. And so you basically had to keep that above 8 feet, also above the vehicle height, which I think the vans and full-size trucks now are 6-7 feet tall. So.
So then, what happens, because the sign ordinances haven't changed in this conversation? Wendy's is looking to redo their site. They were going to go outside, they're temporarily splitting it up, so they're only working on inside right now, but eventually they're looking to redo the outside too, right? Wendy's has a pole sign. Based on their changes, they would be required to pull that down under ordinances, correct?
That's what we're telling them, yes.
So what would happen if they look at the Pep Boys decision and they decide to do something similar, or they see Pep Boys in a different light, well, that's spot zoning, and, I mean, what happens then?
Well, I'm not an attorney, but it sure seems like they didn't have the change of use. And they might have an opportunity there.
They might take the same position.
Which one? Come in with a nonsense thing first and
No,
then sue?
No. They'd probably go with the fact, if your practice is allowing them to continue, use is still the same, it's just modernized, we ought to keep it. So then they'd be forcing us to make a decision on whether to sue them or whether to say, yeah, that is. So, we'll see. I mean, administration is trying hard with
Oh,
them.
I believe that.
Yeah,
I know they are.
to work on it. So, that's all we can do right at the moment.
So I have one other question on the Pep Boys issue. So it was my understanding during that they were allowed some extra wall signage as part of the negotiation when you originally told them to take down the sign. So now that they got what they wanted in the sign, was that part of the settlement that they got to keep that extra wall signage?
I believe, yeah, well, part of the agreement, I believe they get to keep all their signage. Those were directionals like oil change bay and brakes bay and stuff like that. So I don't know if that was addressed. That was reviewed by our liability attorneys, or who is it? Our insurance company's liability attorneys. So
I think it was simply correctional signs, which you do see at a lot of those types of businesses.
Okay. All right, is there any other questions about the Pep Boys settlement before we move on?
So I guess I would have a recommendation because there are other cities, and we know that there's some around us that do not have tall advertisement of a business such as a gas station or a convenience store or whatever as part of it. Is that still one of the zoning prerogatives to talk about that style and aesthetics of signs in relationship to height?
I'm not going to address that right now.
Well, okay, so
that's all right,
Not
but
that
I
it
guess
will
if
only be in
something,
consideration, but it will be in consideration.
so if something comes before us, then I would be requesting a whole lot of advice, and I'm sure you guys will give it, but, and background and that kind of stuff, because it's kind of hard to put that in perspective for
Right.
somebody that's not trained in that particular area.
I remember a study back when we put this together of people looking up to the pole signs and taking their eyes off the road, but I never did find it in our records. But you've been around long enough, you probably remember that discussion also.
Did you just call
No.
someone old?
He's been
Around a long time.
He joined the board when he was 16.
Yeah, okay, right. Thank you. Good comeback.
Out of curiosity, when you were talking, Jim, about the reduction of the sign ordinance that's going to take place, you said it's over 80 pages right now. Is that right?
Correct.
When that is, I don't know how long something like that takes, but when that is finalized, would that be something that can be made available for all of us to make sure that we are up to date with the sign ordinance, since we will be, required to reference that in our decisions? Is it possible to make that available to us?
Well, it should be in the
It's
ordinances.
possible, but changing the ordinances always go through the planning commission and public hearings, and then get voted on by council. I don't know if it's possible to bring it to you, but it's not necessary to bring it to you by the.
No, he
By the
means
laws.
once it's done.
Once it's, yeah, no, I'm talking about the completed version.
Oh,
I
yeah.
mean, I think it would be in our best interest as a board to make sure that we are under the understanding of all the changes that are made.
And
I mean,
maybe
in other words, we could read it, but it would be nice to have a presentation to go through it.
an
and make sure we're
explanation by
clear
the
on it.
planner or
Yes, the
or the
clear
attorney.
speaking planner.
Well, there's another way to expand on that as well, and that is that if the sign ordinance is adopted, as I said, there will be an index of the types of signs we're talking about. We might be able to get your input and suggest to you the input on the considerations that you believe you'd like to take into account when these applications come before you and signage is an issue. So you're making a factual-based record upon which you make your decision that is then justified if they decide to take it up. And I think that would probably be a necessary framework of that ordinance.
You actually just referenced my next question. Was what I was going to ask was will this board be involved in any way in framing and shaping the new sign ordinance? Will we need to be? Is that
No.
something that?
You as a board wouldn't, but you'd be able to speak and discuss it at the public
Yeah.
hearing.
And I think that's an important function. Everyone has input on it. It's just not, the views of us, it's the views of the group.
Okay, thank
Thank
you.
you.
So the next item on the agenda is the large lot ordinance update. I think Jim is here to speak on that.
Yes, we had put together a large lot ordinance back in 2012. There's been 2 variances on it, one in 2014. And then, well, it wasn't a variance, there was a lot split that was requested of a large lot in 2014. And then we recently, just a couple months ago, we had a request for a large lot split. And there was difference in interpretations of the writing of the large lot ordinance. John and I had a discussion in front of council with opposing viewpoints, and council ended up deciding that the language didn't have a statement that said lot splits were not allowed, but there was parts that John pointed out that it was implied. And since it didn't have that statement, they voted to allow a lot split. The large lot ordinance, we were directed by council to readdress the large lot ordinance. John and I worked together, putting a large lot ordinance together with the changes. Some of the changes that the Planning Commission didn't like is I switched the 100-foot width of a lot, defining a large lot to greater than 100 foot. So they asked for that to be changed back before they read it again and set the public hearing.
To equal to or greater than?
Yes. My thoughts behind that is our minimum lot width is 50 feet. So if you had a lot that was the minimum width of 100 feet, you have part of the ordinance saying that you could split it into 2 lots, and then you have the large lot ordinance that says you couldn't split it. Also, they were concerned about the 35% lot coverage and the setbacks. The original ordinance reiterated parts of the R1 and R2 development standards. So I had pulled that out, so the Planning Commission didn't realize that those were still in there, even though they weren't in the writing of the large lot ordinance, because there's a section that says you have to follow the development standards of R1 and 2 districts, the residential districts. And then there was wording on matching the integrity of the neighborhood, complying with the neighborhood. And you remember Reese pointed out that there'd be difference of opinions on splitting of lots with what would match the integrity of the neighborhood through different people. That part of the ordinance, it's a land division ordinance, so you're only supposed to be considering the land division, not the types of structures they're putting on the property, because modern houses are quite different than most of our 1950 subdivision houses. So with that wording of the ordinance, I'm going to pull there was a section that I put in there saying that large lots could not be split unless an appeal was made to the Zoning Board of Appeals in compliance with the wording of fitting into the neighborhood. So I'm going to take that part off that says right after large lots can't be split and can be appealed. I'm going to cut that off and just leave it as large lots aren't going to be split, and take out the development section that refers to the character of the neighborhood. The character of the neighborhood was part of the ordinance defining why they wanted to preserve large lots, and I paraphrased the original ordinance. We're going to have our planning firm, Giffords and Webster, look at it. I got a text from Susie saying that they had a conflict tonight, and earlier in the day she told them that they didn't have to be here since we had so few items on the agenda. So it's not their fault that they're not here. I'm blaming it on Susie. or blaming it on her for not bothering to tell me. So I did pick up McKenna's last assignment for us, which was to recreate the large lot maps. We have individual subdivisions that fall under these large lots, and then we have individual properties that fall under the large lot ordinance. And there's approximately 20 of them that I thought allowing a lot split would be reasonable for protecting their rights. And it's been pointed out that all zoning regulations are that control or regulate people's rights on how they can develop their properties, so we don't have industrial buildings right next to a residential house and stuff. So it's just, I drew the line a little differently than other people. So it will be a different color. There's 3 criteria: 100-foot width, 10,000 square foot of total lot, and 200-foot depth in the original ordinance. So this is just the over 10,000 square foot map that was created by McKenna back in 2012. So I'm going to get the new maps together and get them to the Planning Commission. They're not having a meeting next week, So it'll be the first meeting in February that we'll have everything together. And then they will set a public hearing, which has to be 15 days after they receive their next meeting. So it'll be their first meeting in March will be the public hearing on the large lot ordinance. Reese asked me to put this on here because I had actually put in a section of the ordinance that referred to the zoning board of appeals, saying people could appeal to you guys. Now, that doesn't mean you're never going to hear a large lot appealed before, because if somebody applies for a large lot, it has to go to council for their decision. And then if somebody's aggrieved by the decision of council, they have a right to be heard by this board to see if they can either proceed with circuit court action, or if there's a reason that's pointed out that council didn't hear, so.
And I think when they say someone aggrieved, it's someone who's aggrieved that's within 300 feet of the lot for which the lot split has been submitted. There's that limitation. And there's a recent
You
decision.
mean it has a legal right to aggrieve, because
Yeah,
anybody
legal
can
right.
grieve.
Yeah.
But you
Anyone
mean a
can
legal
but
right.
the legal right is confined to that requirement. And there's a recent decision that just came out on that, to reiterate it. There may
I did not
still-
know that.
Yeah, there may still be some issues with this, but we'll see. The goal is to tighten it up. When we put in, and I wrote this section similar to the character of the neighborhood, I'm looking at this as one large lot, and there's one house on each lot, not more than one. So that's your character. And I hope I'm correct in that, or else it's just a large lot without a house. But that's the character that you're trying to protect, and that reflects that whole area. That is.
But you took that out, right, Jim?
I left it in the purpose statement of the ordinance. We're going to have our planner look at it, see if they can tighten up the language, but I took it out of the appeal part of the ordinance.
So, I'm just going to say this again. If there's any possibility that this could come in front of the zoning board of appeals, which obviously any time someone wants to appeal something, that's where it comes. That's what we're here for. If there's any possibility, the standard for a zoning board of appeals is that we have a specific and objective definition, set of definitions under which we would make a decision. Does it do this, X, Y, Z, and so forth, just like we did for the sign, right? We go down the list and we say, does it meet this? Okay, and so without that, we cannot make a good decision without some objective criteria through which to measure whatever we're being asked to vary. And I would disagree about character, because character can be defined, you might define it that way. I might define it by 6 trees on the lot. I might define it by, in a number of different character ways. So I think you have to define character then. You have to define these terms.
And what you've just outlined as the subcategories to be considered for that, I think is a good idea.
Well, it's not a good idea, it's the way it's supposed to be.
Well, okay, it's the way it's supposed to be. So all we need to do is then, the planning commission, come up with those criteria.
Or, well, I think
Does-
Giffords can help you with that. I mean, that's what they're
Yeah,
supposed to be good at.
And I believe that the way we've been doing it since I've been here is we have the basic ordinance, and then we have a finding of facts. Does it meet the criteria that you're talking about? But I don't know if we've ever put statement of facts in the original ordinance.
And it might not be, but where did they come from then? And from what perspective do we use those to decide if it meets something to grant a variance? You just can't say, come before us for a variance. Okay, but our ordinance says no. What is our basis for granting the variance? Am I missing something? We need a basis to grant a variance. We can't just say, I like it, I don't like it, well, I like it, and then go. I mean, because you're going to be in court forever with that.
Yeah, you already have that standard in the sign ordinance that sets up your authority, and there are about 20 items under it.
Yeah.
Yeah.
So somehow, some way, that has to be articulated.
So I'm going to lean heavily on our planning, new planning
Outstanding.
firm.
Okay. Are there any other questions regarding this topic?
None.
You said the first meeting in March, that's the first council meeting in March or the first planning meeting in March?
Planning's going to receive the administration's version of the ordinance, decide if they want it to be what's presented to the public for discussion. I'm hoping that it is. If it is, then they will set the public hearing that's in front of the planning commission. It has to be at least 15 days from that meeting, so, which puts them into the first meeting in March. And then after the public hearing, either they can make a decision the night of the public hearing or wait till their next scheduled planning commission meeting and give a recommendation to council for their next meeting. Government. 3 months.
Community process.
Yes.
Thank you. Before we move to adjournment, are there any other issues from the city you'd like to discuss? Any other questions for the city? Okay. So before we adjourn, I do want to read an email I got from Mr. Parker. Regretfully, I must tell you that I'll be resigning from the ZBA effective immediately. As you may know, I have a new job and have since moved to Rochester Hills. I've been honored to serve on the ZBA, and I'm very proud of the contributions that have made to the city of Clawson on its behalf. I'm certain that the board will continue to make the best possible decisions and set the proper precedents for this very special community. Please pass along my thanks to everyone. So I just want to say thank you to Mr. Parker for his service and his very thoughtful deliberations. But with that, we do have an opening on the board. And we have two alternates, Mr. Hildebrandt and Mr. Cook. Mr. Cook was not here because his wife just recently had a baby. So he's home taking care of his new baby and his very tired wife. So they were both sworn in at the exact same day and time. So the process that we would propose is if both of you would like to serve on the board as a full board member, then we would propose a coin flip, and then whoever won the coin flip would be would sit on the board, and then the other one would remain an alternate. Excuse me. So Matt expressed his desire to sit on the board. So would that be your desire too?
Yes, absolutely.
Okay. All right. So
Who's got a coin?
I don't.
I don't either. No, actually,
Does somebody
I do.
have a quarter?
I do. I have a
Penny
quarter.
right here on
You
the
got one?
table.
She's got one. Victoria
It
has
was
one.
right here on the penny.
Victoria has one.
That's funny. It was right here.
Yeah.
Keep that.
So it's a quarter, heads and tails. Greg, since you're here, do you call heads or tails?
Tails.
Tails. And it is tails.
Congratulations. We believe you.
Okay, just
faith
want to
in
make
you.
this clear. So thank you, Greg, for your willingness to serve as a full member of the board. So with that, Matt will remain an alternate. And then I guess if you could just let council know we're in need of another alternate to
Okay,
give us
absolutely.
a completely full board again. And Greg is all sworn in, correct? He doesn't
That is
need-
correct, yep.
Okay.
So he will be a permanent voting member through Mr. Parker's term, which expires at the end of this year. And at
Okay.
that time, he could file for reappointment.
Okay. I was going to ask what was the necessary steps for that?
Just
Just refiling, basically?
Yep, at the end of this year,
Okay,
absolutely. And I can forward you an application at that time.
perfect. Perfect.
Okay, thank you.
Thank you.
So is there anything else before we adjourn? Can I have a motion to adjourn?
I make a motion to adjourn the meeting.
Okay,
Support.
Support.
all right, all in favor?
Aye.
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 Thank you, everybody, and Happy New Year.